Thanks. Hi, everyone. I hope everyone is doing well. As Ann mentioned, my name is Tim Mays. I'm the president this year of the Real Estate Section Board, and I'm an associate at Miller Star Regalia in Walnut Creek. And I have the privilege of introducing the topic and the speakers for this morning. So without further ado, today's topic is on quiet title and statute of limitations, as well as third-party escrow liability and recent updates in related law. We have two speakers this morning. First is Dominic Signorotti. He's a partner at McKenna, Brink, Signorotti, and focuses practice on real estate and business litigation. He is a graduate of UC Berkeley and holds a JD from UC Hastings. Our second speaker is Tanner Brink. Tanner is also a partner at McKenna, Brink, and Signorotti and focuses his practice on real estate and construction litigation. Both Tanner and Dominic have extensive experience litigating all sorts of real estate matters, ranging from lien and easement disputes to partitions to complex land use matters. And Tanner is a graduate of UC Santa Barbara, as well as the University of San Diego School of Law. So without further ado, I will turn it over to Dominic.
All right, thank you for that, Tim, and thank you, Ann. So everybody, we're sharing the screen. Hopefully you all can see this. What I'm going to start talking about is quiet title and statute of limitations issues. And what we're going to do is there's a question and answer box. After my portion of the presentation, people will be able to ask any questions. We'll have just a brief Q&A, and then Tanner will be able to get into his part of the presentation. So without further ado, quiet title. So generally, what is quiet title? Quiet title is a way to resolve adverse interests with respect to real property and personal property. There's quiet title statute, starts at section 760 to 765 of the Code of Civil Procedure, and it can be used for a wide variety of things. It basically deals with lien disputes, possessory disputes, ownership disputes, whatever it may be, resolving who has the right, who has ownership, who has title to property. In the context of real property, which is really what this presentation focuses on, you're able to determine adverse interests and rights with respect to specified individuals, but also with respect to the public at large, known and unknown persons of the public. So it's a really broad tool to determine conclusively who has rights to property. One question that often comes up in dealing with quiet title is, well, what's the statute of limitations? And there has historically been some level of confusion because unlike many types of claims, there's no statutory statute of limitations. There's nothing within the code that says, hey, it's 2 year, 3 year, 4, 5, or anything like that. Instead, what the case law and the statutes require is that we look to the quote-unquote gravamen of the cause of action. What really is the underlying cause of relief, the theory that you're working on, and that in turn is going to determine what the statute of limitations is. As you can probably imagine, that often leads to some level of communication because it's not as clear, as if you have a malpractice claim or a certain tort claim where we can look and everybody can agree we have a very specific statute of limitations. Instead, the parties can often have disputes as to, well, what is the gravamen of the action? What is the real theory here that we're pursuing in the quiet title context? And that in turn is going to depend on what the actual statute is that can be applied. So I've put some common statutes here. Generally, if we're talking about a fraud or mistake claim, say it's you're reforming a deed of trust or a grant deed, you're generally talking 3 years. Cancellation of instruments, you're generally talking 4 years. Breach of contract claims. Adverse possession, which is often found in the quiet title context, you're generally talking 5 years. So it's just one of those rules to be aware of, that before you even start the process of figuring out when the statute begins to run, you need to figure out what the statute is. So that leads to really what the purpose of today's presentation is. When does the statute of limitations begin to run? So generally speaking, the statute runs when the injury occurs or when somebody knew of the injury or should have known about the injury. all of the standard exceptions for regular tort claims or other real property claims, they apply in the quiet title context. Delayed discovery, continuing violations, continuing accrual, those are all relevant in this context. The real issue here for quiet title is that there's a long history of case law that says that for quiet title actions, the statute is not going to run for so long as somebody remains, quote unquote, in possession of the property. And cite the Tannhauser case from 1947. These cases actually go back to some of the earliest California jurisprudence from the 1800s. And those trace back to English law, talking about equitable claims dealing with personal and real property when the statute actually begins to run. And the thinking is that, listen, so long as you actually hold the property, physically hold something, or you're physically residing on land, the statute's not going to run. So what's happened over, really over the last 20, 30 years is this issue of what does possession mean has been expounded upon. So in the Sears case, another Supreme Court case, the Supreme Court said, well, possession actually means undisturbed possession. And then they sort of left it at that. They didn't really get into, well, what specifically does undisturbed possession mean? And that's where some of the recent cases that have come out have gone towards explaining, here's what it means to have your quote-unquote possession, quote-unquote disturbed. So the basic thinking behind this rule is that, again, as long as you remain in possession of property, it doesn't make sense to force you to have to resort to litigation within a specific period of time just to establish your right to the property against claims that people may be asserting but not actually pursuing. The Mukhtarin case is another good one where the Supreme Court talked a little bit about what the underlying purpose of the rule is. And what the court said there is that, listen, even if you're aware that there's adverse claims against you, say I own my home and somebody claims that they have actual title to that property. They don't do anything about it, but they're making the claim. What the Supreme Court said is that it doesn't make sense to force me to have to spend the time and the money to establish my rights to the property against a claim that may be floating out there. So to a certain extent, I'm allowed to sit on my rights knowing that there's adverse claims against me, but I don't have to do anything about it as long as I remain in possession of property. And the same thing applies to personal property. I'll talk about a case involving a classic car where even if somebody is claiming that they have title to personal property, so long as you remain in possession, and there's always some exceptions to the rule, but for the most part, so long as you remain in possession, the statute of limitations on the quiet title claim to conclusively resolve title is not going to start. So the Sears case was the first case where the court started to use undisturbed possession as opposed to just possession generally. Up to that point, for the most part, the Old English cases that the California Supreme Court was relying on in the 1800s, and the cases really up to Sears just used the word possession. So in 2015, there was a really good case, Salazar versus Thomas, and I'd suggest anybody who's interested in this to read it, because what the court does is really trace through the history of how did we get to the point where we're at, where we're talking about undisturbed possession and disputing possession. They go through the whole history. It's an interesting fact case. It's involving forgery and fraud and all kinds of, fun facts. But what the court took away in describing how we got to this undisturbed possession is that disputing possession means having the validity of one's occupancy, dominion, or control called into question. So the court talks a little bit about, well, what does occupancy, dominion, and control means? Occupancy is simple enough. You're physically residing at the property. You're exerting some level of control over the property by physically being there. Dominion is a similar thing. It can involve physically residing at the property. It's applied to situations where you're a landlord and you have tenants that are paying rent, that you're leasing the property to. You're exercising your dominion. It also goes down to physical control, which we've seen in personal property cases. you physically hold the property at issue. And even if somebody is claiming that they have greater rights to the real or personal property, so long as you're occupying, exerting your dominion, or exerting your control over it, what the Salazar case says is that that is not going to start the statute of limitations. So that's the basic rule where we are today. Salazar is really the last case to conclusively define, here's the basic rule that we're dealing with when it comes to when the statute's going to start. So that, of course, leads to, okay, well, we know the basic rule, but how does that apply in specific circumstances? How can we expound that basic rule to similar things that we're going to see in real property cases? And one of the main ways in which it's been explored is in the context of foreclosure. So both tax foreclosures, non-judicial foreclosures, any of those types of cases involve, basically at their essence, somebody asserting some right to property, right? If it's a tax sale, you may be dealing with various jurisdiction or authorities, FTB, whatever it may be. If it's a non-judicial foreclosure sale, you're generally dealing with a lender that's asserting some right to take physical possession, to take physical title of the property from you. So what I've done is gone through a number of cases where we have actual examples of courts applying the rules as to when is possession disturbed. And I think looking at all of these together, the courts are starting to come to a pretty, I don't want to say a bright line, but a relatively bright line as to, at least in the foreclosure process, when are we going to have the statute running? When are we going to allow people to stay, not have to file any sort of lawsuit, because even though there's an adverse claim out there, they haven't actually done anything about it. So these are examples of what does not disturb possession. Recording a notice of default. So this is what Salazar talked about, and it relied on an older case, Garfinkel, which was a Supreme Court case. But what they said is, in the context of a non-judicial foreclosure, we have a number of statutory steps that have to be that have to be followed to get to the point where the lender is able to take back title to the property. And the first of those is obviously recording a notice of default. Well, what does that do? A notice of default, as the Salazar court explained, puts somebody on notice, puts the property owner on notice, that if they don't take certain steps, generally becoming current on their lien, there is a chance that the lender could effectuate a non-judicial foreclosure sale and take back title via trustee's deed. What the Salazar court said is that that isn't enough to actually disturb possession. The lender at that point, the time they record a notice of default, they don't have any right to force you out of the property. They don't have any right to take title to the property. Frankly, they don't really have any right to do anything other than start the process. All they're doing is saying that, listen, if you don't do X, Y, and Z, we may have superior rights to title. So that's not enough. The Mayer case is another good example. This was in the tax foreclosure context. In Mayer, these individuals owned a property, and they received actual notice that there was going to be a tax sale. They didn't think it affected their property, but in reality, it did affect their property. Lo and behold, the tax sale goes through. The purchaser at that sale now asserts an actual possessory title right to the property. And what the court said is that it was at that point where somebody has a competing interest in title. They can assert that they have title to this property, that the statute of limitations actually began. The fact that the property owners had notice that there was going to be a sale, that's not enough. Eleanor Licensing is another good example. And this one dealt with personal property, a classic car from the classic Nicolas Cage movie, Gone in 60 Seconds. Very underrated movie. Anyway, what the court said there is that you had a classic car and you had two entities that were having a fight basically over who actually had correct title to this car, who had the right to own it, to possess it, to use it, to sell it. What the court said there is that there was a 5-year period of time, it was 2009 to 2014, where Eleanor Licensing had possession of the car. The defendant had quote-unquote title to the vehicle. They believed that they had actual ownership rights. Illinois Licensing knew about this the whole time. For 5 years, they didn't do anything about it until at some point there was an actual levy asserted and possession of the vehicle was taken from Illinois Licensing. What the court said was that it was at that point that they actually physically lost possession that the statute began for quiet title. The fact that they knew about a competing title claim, it didn't start anything because they retained possession of the property. And that leads to the recent case, Huang versus Wells Fargo Bank. What the court stated there, they went a step further than in Salazar. The fact that a notice of default was recorded doesn't start it. We know that from Salazar. In Huang, a notice of trustee sale was recorded. And the argument was that the notice of trustee sale put the Huangs on notice that if they don't do anything within 20 days, there is a good chance that the bank is going to foreclose and be able to take title to the property or sell it to a third party via trustee's deed. What the court explained in Huang is that the notice of trustee sale itself, it's more equivalent to a notice of default than an actual trustee's deed. Because again, it's putting the parties on notice that if they don't do something, they may very well lose title to the property. And even though the notice of trustee sale is right up at the edge of a foreclosure sale, the court in that case wasn't willing to say that that in and of itself had any effect on dominion, control, or occupancy of the property. So what are some examples of what does disturb possession? And this is where I think we're getting to the point of where some sort of bright line is forming. So we know that in the foreclosure context, notice of default doesn't do it. A notice of sale doesn't do it. However, in the Kaufman case, the court said a notice of certificate of tax sale, that's the equivalent of a trustee's deed. That does start the statute of limitations. It does disturb possession because at that point, somebody now has an actual claim to have title to the property, title that has now been transferred to them pursuant to the certificate of tax sale. The same conclusion was reached in McCaslin. Notice of a completed foreclosure sale. That starts the statute of limitations. So in a situation where you remain in possession of the property, you're physically living at the property, but there's a trustee's deed that has now been recorded which challenges your title to the property, that is going to start the actual statute of limitations. You're no longer allowed to sit back and wait for that claim to actually be asserted against you. As far as the courts are concerned, that's when the claim is now asserted against you. So, getting back to what this bright line is in the context of foreclosure, for the most part, it seems that anything short of not necessarily the actual sale itself, but the recordation of the trustee's deed is going to be where that line is drawn. And it is an open question as to, well, what happens if a non-judicial foreclosure sale goes through? And, on the courthouse steps, it's sold to a third-party bidder, the lender takes title back. Who knows? That's something that presumably the courts will answer in due time. But at this point, we know that it's going to be somewhere in between. The notice of sale is not going to be enough, and the recordation of the trustee's deed is going to be enough. So we have some wiggle room in between those two, and we don't know exactly where that line is going to fall. If I were betting on it, I would say it's going to be much closer to recording the actual trustee's deed or certificate of tax sale. So that's generally where we are in terms of what happens when determining when you need to actually file an action to quiet title to real or personal property. If you're aware of adverse claims out there, you don't necessarily have to do anything. You are running a little bit of a risk, and I'll get into that in a minute, but you don't necessarily have to do anything until you get to one of these points where your dominion or control is actually being challenged. And that leads to the exception of the rule, latches. So what the court said in Mukhtarin, in Salazar, they touched on this. In the Huang case, they touched on this, is that even if the statute hasn't run, even if you remain in possession of the property, that possession is undisturbed, you're aware of an adverse claim out there, but they're not pursuing it, you have the right to sit and the statute won't start to run. However, it does create a potential defense by the adverse claimant for Latches. The idea is that you can't delay indefinitely and cause some sort of prejudice. And I think realistically, the situations in which this is going to apply are probably not many. One thing I will say is that in the Huang case, which was recently decided, that actually might be a candidate for Latches, because what happened there, sort of a funky turn of events. You had owners of property, and they took out 2 lines of credit. They ran them up, they refinanced everything, and the idea was that the refinanced loan that was coming in was going to pay off the lines were going to be closed. A mistake was made. The lines were not closed. Actually, they were closed and then they were reopened. And what did the former owner do? Well, what a lot of people were doing back in the heyday, I guess. They ran up the lines and they left. So the property was foreclosed on. The lines, because they were never closed, ended up being in senior lien positions to the refinance loan itself. So long story short, the Huangs ended up purchasing the property from the lender after the foreclosure sale. They didn't understand or didn't realize, because their title report didn't catch it, that the 2 lines of credit, which had been maxed out for close to $200,000 total, they remained secured in senior positions on the property. So they find out about this shortly after purchasing the property. They go to their title insurer, Fidelity. Fidelity contacts Wells Fargo. They have a discussion. Everybody's aware of the fact that these liens are out there and they are missed on the title report. Wells Fargo and Fidelity are discussing some form of settlement, and then for reasons that nobody can explain, both sides just forget about it. They forget about it for approximately 5 years. Nobody does anything. The Huangs are under the impression that the matter's been resolved. Fidelity's not pursuing it anymore, and Wells Fargo's not pursuing it anymore. Till about 5 years after the fact, Wells Fargo records a notice of default, and they start the foreclosure process again. They somehow realized these liens remained out there. And it's at that point that the Huangs filed their quiet title action, and we got into the whole dispute as to, well, when does the statute start running? And even though the appellate court concluded that the statute did not start running because the Huangs, during the entire time that they owned the property, they remained in possession, and the notice of default wasn't enough to start it, the notice of sale that was eventually recorded wasn't enough to start it, but the court did mention at the end of its opinion that, listen, even though the statute hadn't begun to run, this is potentially something where Wells Fargo, due to the passage of time, may be in a position to assert a Latches defense. So we'll see how that all plays out once we get back to the Superior Court. That's just something to keep in the back of your head. So that's my portion of this. Now I think what we can do with Ann, and I'll let her figure out how to make this happen, is we can answer any sort of questions people have. So I guess, Ann, we can open it up for that.
Hi. So we have one question. Well, first of all, I wanted to let everybody know that the materials will be sent out tomorrow, or maybe later today if we're lucky. So we have that. And then we have a question from Ann Batten, and it's regarding deeds of trust and legal title. How does one deal with an apparently abandoned deed of trust? Does the recordable Marketable Title Act force the 1060-year rule against the right to quiet title?
So, Ann, I think I understand your question, and the answer generally would be yes. So if we have an abandoned deed of trust, you know, that's a tough situation because your options are generally not good. The ideal option is to find the beneficiary or find the trustee or successor trustee and get them to sign a reconveyance. Oftentimes, that's impossible because they're no longer around. And in those types of cases, really the best thing to do is file your quiet title action. Generally, they're not going to appear, and you can go the default route and then get some kind of court judgment. In terms of when the statute begins to run on that, it's really going to boil down to, well, when did you know about this? Because the fact that it's abandoned is assuming that they're not pursuing it, so there's no real risk of them disturbing possession to property. It's just a deed that remains out there, and once you learn about it, you should either seek to get it reconveyed or file that quiet title action.
Okay, are there any more questions? You can put that into the Q&A or preferably not the chat, preferably the Q&A, but if you don't have the Q&A, go ahead, put it in the chat. And there'll be time for questions at the end as well, I'm sure. So, okay, I guess that's it for Dominic.
All right, and I'll turn it over to Tanner.
All righty, good morning, everyone. My name is Tanner Brink. I hope no one minds that our dress code has kind of changed in the last few months to golf shirts and flip-flops as opposed to slacks and ties, but that's where we're at. I'll just begin by giving a brief recap of personally what I do and what our firm does. About 75% of my practice is devoted to litigation and has been for most of my career. About 50% of this is real estate disputes of all kinds, both as plaintiff and as defendants, as the case may dictate. Dom and I are outside panel counsel for a number of escrow and title insurers. So these cases range from representation of the company themselves to representing their insureds on cases ranging from specific performance to quiet title to easements, pretty much anything and everything related to real estate. I'm also outside general counsel to a number of local companies, ranging from your small contractor to your mid-sized general contractor to your startup companies to your employee search firms. And so that scope of my work is anything and everything. They will call when they need something completely outside the scope of my expertise. They will call when they need a divorce attorney or a criminal attorney. And I've made it my life goal to avoid those areas of practice. So I will call the appropriate person that I trust and get them squared away. So a little bit of anything and everything related to general counsel. We started our firm about 9-10 months ago. I and Dominic and Erica left a larger firm to do a kind of serve as a one-stop shop for most of our clients' needs. For example, many of my clients will need an LLC to be formed or a purchase and sale agreement. And I can walk next door to Erica and have her do that. Dominic can do a little bit of everything. I just had a client who wanted to franchise a portion of his company, and I knew enough to have a conversation about it, but that's about it. So I took him to Dom, and Dom was able to get him straightened out. And then we most recently, about a week before March 17th, hired a new estate planning, tax, and wealth preservation expert, that his name is Ryan Lockhart, and he can handle all your probate needs and wills and trusts. So that's essentially what our firm and I do. I wish I had a more exciting topic like college football to discuss here today, but sorry about that. But my presentation today will focus on escrow entity liability to parties that were not included in the escrow instructions themselves. This can be an important issue for most of you, even if you don't deal with it. If you happen to be involved in defending one of these actions, it will be critical for you. Also, if your client is asking whether it makes sense to name an escrow or title company when your client is not a party to that transaction, you'll be able to advise them on whether that's appropriate or not. We just had one particular client who was dead set on naming the escrow party of the person that sold a property to him. And so we were able to tell him, you're not likely to succeed on that, and it's likely to cost you several $1,000s to not succeed on that action, and he decided against it. So there are a number of reasons why this could be important to each of you. I briefly prepared this initial slide, which is just briefly an outline of the escrow liability to third parties and the most relevant case law. All pretty straightforward. There's plenty of law and code provisions on this and the lack of liability to third parties. So I won't go into extreme detail on this, just for your basic knowledge, what I've decided to do is just kind of give a case study example of 3 cases we've dealt with recently on this issue. We've had, I think, 5 or 6 cases of direct naming of the escrow and title companies just this year. So I want to go over 3. One was where frankly, I think the court got it wrong. 2, I think the court got it right and agreed with us. So I'll do the first one where we think they got it right. This first case I want to talk about was actually a probate matter and an 850 petition. In that case, we represented a large escrow and title company who was named as a party to the 850 petition. Essentially, this case boiled down to a will dispute, i.e. who was the proper beneficiary, because there are 2 wills. The most recent beneficiary of that will put the property on the market, sold the property to a third party, and our client was the escrow and title company in that transaction. After the sale was done, a dispute arose as to who was the proper beneficiary, but this came to light well after the escrow and sale. Our first 2 demurs were sustained, and the petitioner named us again, focusing on allegations that the escrow company themselves negligently prepared and recorded documents in connection with the escrow. They also alleged that we failed to follow proper probate code requirements, failed to get a probate referee, and failed to list the property on the MLS to maximize the sale price. These were allegations against the escrow company. At the end of the day, the court, this was San Francisco, the court sustained our 3rd demur without leave to amend, stating that the petitioner had not stated a valid claim against our client, the escrow company. The court held that our client had no duty to petitioner to investigate which will controlled and to maximize the sale price. In our opinion, this was the correct result. The alternative simply didn't make any sense. It would require an escrow company to essentially perform the functions of a mini trial to evaluate who was telling the truth or who had competence to do each will or take depositions. That's just not what an escrow company does. Additionally, the claims in that case that the escrow company was required to maximize the sale price of a property would essentially turn them into a realtor or a broker, and that's not what they do. And if that were the case, then the price of an escrow would quadruple, if not more. So that was a recent San Francisco case. The second case I want to go over concerned a Santa Clara County demur. Somewhat of a confusing case, so bear with me on the facts. Here again, we represent an escrow company involved in alleged missed easement in connection with the purchase of property. The plaintiff in this case was not a party to the escrow, but was an alleged promisor and brother and business partner to the individual who was a party to the escrow and sale. Plaintiff just did a blanket, very general complaint naming all potential entities under our client's corporate umbrella. And then they didn't describe who did what and what they thought was negligent or stated a viable cause of action. They just grouped everyone together. Voluntary document productions prior to the demur hearing showed that each entity was a distinct entity in what they did and what their roles were in the transaction. And again, plaintiff on demur just treated them all the same. Didn't explain who did what they alleged was wrong, none of that. The core of the complaint against our respective client was that the company improperly denied a claim by that third party. And again, he just combined all the causes of action. We, of course, argued at the demur stage that the plaintiff improperly named the escrow company, that the evidence submitted that they were a separate and distinct entity from the title insurance company, and that our client owed no duty to that third party. And that at a minimum, the plaintiff needed to plead exactly what each entity did wrong because they had the documents. So the court, this was Santa Clara, ruled that plaintiff had properly stated a claim for a legal duty And that was basically based on representations, alleged representations made during escrow regarding the plaintiff's business relationship with his brother and business partner, the party to the escrow. The court did leave us room to pursue it further, stating that this was more of a motion for summary judgment type issue. And so we filed that, and that's pending right now. So they were able to get by the demur stage by a non-party to that escrow transaction. Again, I think they got it wrong, but not the first or the last time. The final case I briefly want to go over was I believe that was San Mateo. I'm sorry, the last one was San Mateo. This one's Santa Clara. In this case, we represented a client whose corporate name was identified as both the escrow company and title insurance company. It was a quiet title case. Our client was named in a cross complaint by the heir to a trust. She was not a party to the subject escrow transaction. And then she made a claim in this cross complaint to the property that the trustee eventually sold to an innocent third party. The cross complaint alleged that the trustee informed the escrow officers that she was an heir and that she was therefore a third party beneficiary. She also alleged that even though the trustee was the seller in the transaction, that the escrow officers told her that she would be receiving a policy of title insurance. She based this on the undisputed fact that they did pay for the title insurance policy for the buyer, but she thought she was also going to be covered as the seller. The court, I think in this case, correctly held that she did not state a viable claim with respect to our client as an escrow company. The court, I think, correctly stated that the agency created is limited to the obligations of the escrow holder to carry out the instructions of each of the parties to the escrow, not an heir, despite allegations that they knew about it. There were no allegations in that cross complaint that our client failed to faithfully comply with the party's escrow instructions, and accordingly the demur was sustained. And these are three of the most recent cases this year that we've dealt with the issue. Again, fairly straightforward law, fairly straightforward statute on the issue, but plaintiffs or cross complainants are always trying to get another place at the table in terms of resolving a case. Can you go to the next slide, Dom? Okay, just in brief recap, like I said, title and escrow companies are frequently named in cases that parties are trying to get another hat at the table, right? Oftentimes, almost in all cases, we do file a demur, and most of the time are successful on demur, at least with respect to third parties bringing a case to an escrow. The escrow instructions themselves need to be clear. They need to show what the parties want the escrow company to do, which specific entity is involved for the escrow and the title insurance duties. And this is often the case where they're working under the same corporate umbrella. So you'll have, you want to be clear what entity is doing what and what duties they're responsible for. The escrow and title insurers themselves need to be cautious to let everyone know their roles in the transaction and be sure that the parties aren't confused. The escrow company needs to be identified that they are working on behalf of only the parties to that transaction and not strangers to the transaction. That's where we get into trouble. Happy to answer any questions any of you might have.
I don't see any questions in the Q&A. Does anybody have any questions they want to type in quickly? Anything in the chat? Oh, Steve Kahn's typing on right now. And there it is. Oh, there they are. There's one from Marie Kwashnok. The question is, do you know a title and escrow company, let's see, do you know that a title and escrow company owes duties to other property owners that might put up their property as additional collateral for a loan? In this case, the other property owners were not borrowers.
Well, it depends if they're going to be identified in the escrow instructions themselves, right? So that's another point for clarity. If they want to be to have duties owed to them, they need to be included in the instructions themselves. If they're not, they do run the risk that the escrow company is going to point to the instructions themselves and say, you know, you might have had some involvement here, but we weren't retained by you, we weren't hired by you. So that they run a risk by not putting themselves in the instructions themselves.
So Marie says, yes, they are.
They're in the instructions?
Apparently. So yes.
Yeah, then they will owe duties if they're identified in the instructions.
Okay. Malcolm Schur asks, how many of these cases are susceptible to successful mediation?
Very often. In some of these cases, we try to do an early mediation before the demur stage. Often it's a meet and confer conversation or back and forth. Oftentimes an early mediation is a good option because it avoids thousands of dollars in motion practice and giving these people sometimes 2-3 opportunities to amend. So yeah, a mediation would be a great idea in something like this.
Oh, okay. Steve Kahn asks, what about a closed corporation? Does escrow have a duty to verify whom within the corporation has authority to bind the corporation, i.e. sell real property owned by the corp? Or can they simply accept the representation of the individual that she has the authority?
Sorry, I'm just reading this out loud.
And if escrow does have that duty, do you think it should verify authority and other members of the closed corp? That's in the chat, Tanner, if you want to read that yourself.
I found it. So okay. That kind of goes along with the first case example because you were dealing with a beneficiary to a will who, by all accounts, had authority, and then the dispute came later that this plaintiff says that they didn't have authority. So I think that, let me read this question again. If there's a document showing that this individual has authority on behalf of the corporation, I don't think the escrow company has to do much further digging. You know, they don't need to take depositions to see additional authority. If there's a document showing that they had authority to bind the corporation in the sale, in terms of escrow liability, I think they're fine.
Okay. Any other questions? Give you guys a moment for typing. Dominic's here too, so if you have any other questions for Dominic, he's still around. There he is. Okay, I guess that's it for now. Thank you both very much for doing this. Really appreciate it. And if you guys have any further questions, I'm sure you can get in touch with Tanner or Dominic, and we'll send out the PowerPoint. Will be sent out at some point today or Monday, and any other materials that they get to me. Okay. Oh wait, what's in the Q&A? Oh, thanks. Lots of kudos coming in, gentlemen. So, oh wait, here we go. Mike Buslick. Here we go. Do you happen to know in a probate context, when title company asks for letters testamentary or letters of admission and notice of proposed action to sell property, is that for the purpose of investigation or other? Does the initial investigation inquiry create additional duties or liabilities? That's in the Q&A if you guys want to read that too.
Yeah, I understand what you're asking, Mike, and that's essentially what was done in our probate case in San Francisco. They asked for the probate documents, and that was good enough. Does the initial investigation inquiry create additional duties or liabilities? Not necessarily. I mean, if you have the documents showing that this individual has authority to, in that case, enter into real estate transaction, they don't necessarily, you know, an escrow company is not a probate attorney. They're not going to dive into whether there was capacity or anything like that. They're going to see the documents, see the probate documents, see that this individual, at least on the face, has the authority to sell the property. And that's about the extent of their inquiry duties. I think that answers your question.
There we go. Okay. Yes. Good. Okay. All right. Well, let's see if anybody else has. All right. Count to 10 for typing. All right. Well, thank you very much, everyone. Again, have a great weekend, and we'll see you on Zoom again soon. Thanks, Tanner. Thanks, Dominic. Appreciate your time and efforts today.
Thanks, everyone.
Thanks, everyone.
Bye, everybody.